Hello, everyone. My name is Andrew Hall, and I am a senior attorney with the Blake Law Firm. Today, we're here to talk about alternative dispute resolution, or ADR, as it's known around the legal profession. Oftentimes, when people think of litigation, they think of court proceedings, judges, juries, arguments, motion work, pleadings, that type of thing. But there's also a second, we call it a dual track, often involved in litigation, and that's ADR. And the purpose of ADR is to help the parties facilitate trying to settle the case and give each party a realistic view of the strengths and weaknesses of their case. So the topics that we'll be discussing today, what is ADR, when to use it, a mediation, what is a mediation and how it differs from some other methods and modes of ADR, arbitrations, the differences between judicial and contractual arbitration, and then some of the advantages and disadvantages of using an arbitration. There's also early neutral evaluations, or ENEs, and we'll discuss in a little more detail about those and some of the benefits that ENEs provide. And then lastly, a settlement conference, which is oftentimes a settlement conference in front of either your trial judge or another judge in the courthouse. So at the outset, it's important to understand, what is ADR? ADR is the broad term used to define alternative modes of litigation. It's often used either through mediations, where the parties sit down and try to resolve it through a settlement, through arbitrations, which is a proceeding outside of the courthouse, or ENEs, or settlement conferences. And the purpose of ADR is to allow the parties to, sit down, frankly discuss settlement, frankly understand the strengths and weaknesses of their case, and understand that early on before spending a bunch of time and money in litigation. Oftentimes, ADR is a requirement of courts, a lot of the courts that we see, before even sending the case out to trial. And the reason for that is how impacted the court calendars are. They want to see the parties at least give a settlement or ADR a try before seating and paneling a jury and spending a week or two trying a case. So it's important to understand the nuances of ADR. Oftentimes, the legal terms of art of mediation, arbitration, settlement conference are lost, and it's important to know the distinction between the various methods and modes of ADR. So the first topic that we'll be discussing is mediation. And what is a mediation? So a mediation is a conference between two parties, or oftentimes multiple parties involved in a lawsuit. And the important thing to note about mediations is that it's governed by a neutral third party. And that neutral third party is oftentimes an attorney that is experienced in the industry, that knows the legal arguments and has seen similar fact patterns, or oftentimes you'll see a retired judge. And the mediator's role is not to make findings of fact. A mediator can't issue judgments. There's no rulings in a mediation. While you're presenting your case and some of the important evidence, it's not like a courtroom where you're calling witnesses and introducing documents as exhibits. It's more informal than that. However, the neutral third party's job, the mediator's job, is to ask questions and to express opinions. And those opinions are often go toward the merits of the respective cases. And each mediator handles mediations a little bit differently. Some, try to nitpick at each side and try to bring them into the middle. Others, hammer one side if they think that their case is particularly weak, and try to bring them to the light in terms of getting the case resolved and foregoing, continued litigation. It might, in the end, be futile in the mediator's opinion. So again, a mediator is not a judge. Settlement cannot be imposed. It takes the cooperation of both parties to enter into a settlement for a mediation to be successful. But it's an important tool to assess the viability of claims and lay the groundwork for settlement. Oftentimes we see at mediation, while the case doesn't necessarily settle at mediation, the groundwork for settlement is laid, and it allows the parties to circle back on certain issues down the road and ultimately get the case resolved. If not at the mediation, then outside of the mediation amongst the attorneys and parties. An important thing to know about mediations is that there is a confidentiality attached to it. The purpose of that is to allow the parties to fully and frankly express their views on the case, and for the mediator to do the same. So, for example, if a mediator has an opinion about the case, the mediator can't later be called as a witness at trial. Likewise, any arguments made by the parties at mediation are covered by mediation privilege and confidentiality. So that's important to note going into a mediation, is that there is it does foster an open line of communication and really facilitates the parties being open and honest and trying to get the case resolved. There are there's a distinction between voluntary and mandatory mediations, and as I mentioned earlier, anyone can mediate. It just takes the agreement of the parties and the willingness of the parties to mediate to actually go forward with the mediation. There are some instances, however, where mediation is required, and that's either to prospectively obtain attorney's fees down the road if you're the prevailing party, or to keep going with your case. So some examples of that are if you're a real estate, a residential real estate purchaser, buyer, seller, these standard contracts for real estate purchase agreements contain a mediation provision. And that provision requires that before the parties enter into litigation, that being filing a lawsuit, that they attempt to mediate the dispute. And if an attempt isn't made to mediate the dispute, then even if you're the prevailing party at the end of the day, the court won't award your attorney's fees. So it's very important that parties pay attention to their contracts, make sure they understand the implications of the mediation provisions in the contracts, and if required to mediate, then mediate. So there's some advantages and disadvantages as to mediation. Oftentimes mediations are less costly than arbitration or trial. A lot of that, again, depends on the mediator that you're selected. Mediators have different rates, different abilities, and oftentimes when it comes to mediation, you get what you pay for. So it's important to do your due diligence into the mediator, ensure that that person is qualified to mediate your dispute and has experience in your dispute, and is someone that you think can ultimately get the case settled. Because that's the purpose of mediation at the end of the day, is to reach a resolution and end the litigation between the parties. Another advantage is that there's flexibility. The parties aren't beholden to any deadlines. It's often up to the attorney's party schedule, the mediator's schedule, and just finding an open date there. So there is some flexibility, which is nice. And depending on the mediator, mediations can be scheduled within a week, or depending on the calendar, it could take months. So the flexibility is a nice perk of a mediation. Parties control the mediation process more so than a court or arbitration proceeding. Again, a mediator is not going to set hard and fast dates on anything. They may require a mediation brief, which is the parties' written expression of their case and some important documents, and those might be due a few days before the mediation. But outside of that, it's really up to the parties to find dates that work for everyone and get the thing mediated. The other advantage is it allows the parties creativity in fashioning relief. So if there's cases, oftentimes cases involve complex and nuanced issues that go beyond just a monetary dispute. And the mediation and mediator in particular oftentimes can help the parties creatively settle any issues that a judge or arbitrator might not be able to do just because it's outside of bounds of their powers. So in that respect, mediation is good. In particular, if you have a complex or complicated case that you think might require relief other than monetary relief. Some disadvantages: participants pay out of pocket. The mediation costs are often split between the parties. So that's a cost in addition to any attorney's fees that are incurred in mediating the dispute. Mediations are as effective as the parties want them to be. So if you have, one party that's really wants to mediate and is gung-ho to mediate, and you have another party that is just checking a box or going through the motions, oftentimes those mediations aren't as effective. So, a big part of it is making sure that both sides want to mediate, want to be there, and want to reach a resolution, and are there for the right reasons, not just to check that box to say we've done it. Now, what's next? And lastly, as we've kind of discussed throughout, mediations are formal. You cannot establish legal precedent, make any findings, make any rulings. But it's important, at the outset to mediate cases to assess strengths and weaknesses of the case, and anticipate if the case doesn't settle, anticipate what your other parties' arguments might be moving forward. So oftentimes we see people confuse or conflate mediation and arbitration. And arbitration is different than mediation. Arbitration still involves a third party. So oftentimes, again, a attorney with years of experience in that particular field, or a retired judge. But the difference between arbitration and mediation is that the arbitrator can make rulings and can make findings. So there's a couple types of arbitration. The first is judicial arbitration. And that's where civil action is heard and decided by a court-appointed arbitrator. And this is done before the case becomes eligible for proceeding to a court or jury trial. So if a judge sees a case that might be fit for a judicial arbitration, the court would set a court-appointed arbitrator. The parties would put on their evidence, would put on their witnesses. So again, unlike mediation where there's no formality, a judicial arbitration is a little more formal. That judicial arbitrator will make a finding based on the evidence and witnesses presented, and give his or her opinion on the case. Now, the parties may accept it or may not, and there are implications for not accepting it if the person not accepting it receives a less favorable ruling in the court proceeding than they did in the judicial arbitration. So we don't see these too often, but it is something to be aware of. More often, however, we see contractual arbitration provisions. And a contractual arbitration is where a contract exists between the parties that requires that the dispute be arbitrated. So again, referring back to a residential real estate purchase agreement. Those agreements typically include an arbitration provision where a buyer and a seller agree to arbitrate with a third-party arbitrator. That's a full and complete resolution of their dispute outside of the court's system. The contractual arbitration proceeding is run much like a court proceeding. The parties are allowed to file motions, they're allowed to seek discovery, they're allowed to conduct depositions, and there's a formal hearing at the end of it. So it's important to know when you're signing a contract, look out for these arbitration provisions, because if you're signing the arbitration provision, there's a potential that you could lose the ability to litigate and that you're stuck in an arbitration. And we'll go through some of the pros and cons of that here in a second. But just be aware of contractual arbitration provisions, and if you sign one, you're most likely stuck in arbitration and arbitrating any dispute. So some of the pros of arbitration, it can be speedy and efficient. Again, it depends on the arbitrator that's selected, that arbitrator's calendar, and the ability of the arbitrator. While arbitrators' calendars are much often less impacted than, let's say, a judge's calendar or a court's calendar. So it's easier to get hearings on calendar. It's easier to get the arbitrator's attention than it would be, a judge in a court proceeding. Unlike a court proceeding where you're making filings that are open to the public, Arbitration are confidential proceedings. So filings made in the arbitration aren't available to the public. There's no, for example, docket where anyone can come off the street and access the pleadings or motions being filed. It doesn't work that way. The documents are exchanged with the arbitrator and not provided to any parties outside of the arbitration. The arbitration, kind of like the mediation, but a little bit different, allows more control of the process. So, again, you have an arbitrator making rulings and decisions, so it's not as much control as you would have in a mediation. But oftentimes, arbitrators are a little more hands off when it comes to allowing the parties to dictate some of the scope in terms of the proceeding. So, um, oftentimes parties can limit the scope of discovery to try to keep costs down. They can limit the number of depositions. They can limit the number of experts. They're not necessarily beholden to the limits set forth, by the California Civil Code or California Code of Civil Procedure or the court system. Some cons of arbitration. Um, while they can be speedy and efficient, they aren't always speedy and efficient, and sometimes arbitrations cost uh, more or substantially more than a typical court proceeding. And the reason for that is because, unlike a court proceeding where you have a judge that is on the bench that's appointed, that's being paid by the state or the federal government, arbitrators are paid by the parties. So they often charge by the hour, and the costs are often split. And therefore, at the end of the day, if you're a party participating in arbitration, you're not only paying your attorney's fees, but you're paying the arbitrator's hourly costs to preside over the proceeding. So those costs can add up quickly, and the what should be a more cost-effective solution to court proceedings in an arbitration sometimes become more costly. Um, we discussed a little bit earlier the informality of an arbitration proceeding, and that sometimes cuts both ways. Arbitrations are more informal than trial. It leads to the admission of evidence that perhaps a court might not typically admit, or it might impact a party's presentation of the case. So that informality is a good thing and it's a bad thing, and it cuts both ways, and it's something to be mindful of when the rules of evidence are more relaxed, more comes in, and there's more that an arbitrator could potentially evaluate in reaching a decision on the case. Arbitrations, there's no juries in arbitration. So that's one of the biggest drawbacks of an arbitration, is that it's decided by the arbitrator. And sometimes there are panels of arbitrators. You can do a one person 3-5. That's different than having a jury of your peers. And it's important to know that there's no way to get a jury in an arbitration. So if you're in an arbitration, you're stuck with your arbitrator, and there is no panel of your peers deciding your case. Kind of going along with that, there's no appeal process in an arbitration, or there is an appeal process, but it's extremely, extremely, extremely limited. It's typically limited to misconduct of the arbitrator or something, really outside the bounds of a typical arbitration. Very rarely is an arbitration appealed on grounds that the law was misapplied or that evidence was improperly admitted. So it really kind of hamstrings a losing party's ability to appeal what it believes is a decision that was reached in error. So we alluded to this a little bit earlier, but it's extremely important to watch out for arbitration clauses in your contracts. Um, a couple reasons for this: one, you could be bound by an arbitration and taken into an arbitration if such a clause is included in your contract. But another is if you are being sued. Um, let's say, for example, you're the seller of a residential property, and the purchaser finds an issue with the property and sues you for a non-disclosure, and they sue you in state court. Um, even though your contract has an arbitration provision, that party has the right to sue you in state court. Now, you have the right to pull the case out of court into arbitration, but you're required to do so quickly and without waiving your right to do so. So in that scenario, if you want the case in arbitration, it's important that you remove the case to arbitration quickly and not allow the case to move forward in state court for any period of time that could potentially cause the court to find that you've waived your right to an arbitration. So, excuse me, from both sides of the fence, it's important to know, if you want the arbitration, that you need to pull it out of a state court proceeding quickly as possible if you're stuck there. And on the other side, if you're filing, you kind of get to be able to select your forum there for a little bit. But again, if you file in state court, there's an arbitration provision and the defendant wants it in arbitration, that defendant's most likely can prevail in pulling it into the arbitration. Either way, it's important to consult with your attorney, make sure that you have a strategy in place for addressing the arbitration, and that you make a selection that's in the best interest of you and your case. Moving on, the next form of ADR are ENEs, or early neutral evaluations. And this is typically, we see these more in federal courts than we do in state courts. And these are often required at the outset of a federal case. But these typically involve the parties and the attorneys participating in a confidential evaluation with a neutral attorney with subject matter experience. And the purpose is to really give the both sides an idea of the strengths and weaknesses of their case. And these ENEs are less concerned with settling the case than they are with really giving each party a clear and concrete view of the strengths and weaknesses of their case. And oftentimes that view of the strengths and weaknesses will lead to the parties coming together to discuss litigation, or excuse me, to discuss settlement. So knowing the strengths and weaknesses of your case is an important component of reaching a resolution. And if you have a case that you think might be 50-50, you could be better off negotiating a resolution than taking the case all the way through trial. And these ENEs go a long way in giving the parties and their attorneys an idea of, should I take this case to trial or should I try to resolve it early? So a couple key considerations for ENEs. Again, it's a realistic assessment of the case. They don't sugarcoat things. They don't, it's a neutral third party, so they have no dog in the hunt. So they're going to be open and honest with you about the strength of your case. They're going to look at the likelihood of success. And again, this leads to an assessment of the impact of settlement. If they give you a 20% chance of prevailing, that might be a clear indicator to you that I need to really try to resolve this early on rather than spend time and money and attorney's fees on a case that I'm not likely to win at the end of the day. There's no power to impose settlement. Again, like a mediator, this is more of an evaluation and a providing of information that is, like, say, for instance, in arbitration, where that third party has the power to make rulings. The person facilitating the ENE doesn't have that power. It's merely informational. And lastly, kind of on a related point, the neutral determination is non-binding. No rulings are made, no judgments are made. It's that person's opinion. If you think that their assessment is wrong, then it's your right to proceed with the case as you see fit. It's again informational and meant to give the parties a realistic view to help facilitate a resolution. And lastly, the last form of ADR are settlement conferences. And settlement conferences are kind of like mediations, where you have a third party overseeing settlement discussions, but it's typically done with a judge. And we've seen these done with trial judges. You have a trial call with the trial ready to be set, and the judge asks whether the parties want a settlement conference. They say yes. That judge oversees it. Now, there's tactical considerations to be made in determining whether or not you want your trial judge overseeing your settlement conference. There's a strength of your case, there's a credibility of your witnesses, there's a credibility of the plaintiff and the defendant at stake there. And giving a judge an early view could be, a tactical decision on the party's part about whether they want that early preview with the judge, or whether they think it might be best to have, another judge from the courthouse overseeing these settlement conferences. But they can oftentimes be a powerful tool, because having an actual presiding judge overseeing a proceeding, giving their opinion of the cases is, from what we've seen, a fast track to settlement. And having a judge say, yeah, you have issues with your case, can oftentimes lead a party to say, well, wait a second, let's tap the brakes, let's try to get this thing resolved. So settlement conferences can be used to help settle the case. It's a tactical decision, and it's something that you should really evaluate on a case-by-case basis, depending on the strength of witnesses, credibility of witnesses, strength of evidence, and demeanor of the plaintiff and defendant. We kind of just went over the pros and cons a little bit, but just to reiterate, the pros of settlement conferences, they're useful to have when the parties are already engaged in settlement and they just might need a push over the finish line. Having a judge there lends gravitas toward that, and can oftentimes get the parties to that little nudge toward the middle that they need to get it settled. They are conducted through the court, so there are often no fees required, unlike a mediation where parties have to split fees. The judges are already being paid, they're already there. So that's a benefit of doing a settlement conference with judges in the courthouse. Cons, it can be risky. Again, depending on the facts, arguments, conduct of the parties. Giving the judge a preview of that case, if it doesn't settle, you're still stuck with that judge, and that judge has already made his or her first impressions of your case. So, you could be stuck with that. Parties are often at the mercy of the court's calendars. We alluded to it a little bit earlier, but court calendars are severely impacted. So it could be some time before you could get a settlement conference in front of a judge. And lastly, oftentimes these are conducted well into litigation, if not on the precipice of trial. So by that point, the parties have already expended a great deal of time and money into the case and might, already kind of quote unquote be pot committed on that. But again, it never hurts to discuss and try to reach a resolution, because court trials are expensive. They're inherently risky. And if you could reach a firm resolution and get, a result that you could swallow, it's not the worst of ideas. So settlement conferences help, again, kind of get that past the finish line, albeit you're well into the case, already expended some money, but at least you could buy that sense of peace. So that was a very brief synopsis of ADR. Again, as I hope you can see, there are nuances to each method or mode of ADR. There's some strengths and weaknesses to each. So it's important for you to evaluate your case on a case-by-case basis and consult with attorneys that are experienced in ADR proceedings and committed to resolving your case, rather than driving through litigation without really exploring alternative ways to get your case resolved and settled. I hope you've enjoyed the presentation. Please feel free to reach out to us with any questions, and we'd be happy to discuss further any impact that these might have on your cases. Thank you.